Having established the difference between a term and a representation, and then worked out how we can understand whether a statement does become part of the obligations of one of the parties in the contract, we now need to look at what happens if one of the parties doesn't carry through with those obligations. What happens if they actually breach a term? The specific terminology around this involves the word remedies, and that's an important word because what it's trying to do is to say, how do we fix the situation? Notice not how we penalize someone, it's how do we fix the situation? How do we remedy it? How do we get you back to where you were before the breach occurred? An important concept that we need to go through. So if a party breaches a term of the contract and they don't have an effective disclaimer, then there are a series of legal remedies available to the other injured party. Generally, those remedies fall into one of two classes, the common law class of damages or equitable remedies. And equitable remedies are very specific kinds of actions that the court orders that we're going to go through, an injunction or specific performance. And then, as we learned earlier in this series, in some very specific circumstances, that is when there's been a breach of condition, not a breach of warranty, the injured party might be able to terminate the contract. So let's have a look at each of these remedies. As a general rule, it's not automatic that the injured party can terminate the contract. In fact, they may still have to do what they promised. They can only terminate if there's a breach of condition. They can't terminate for a breach of warranty. And so I would refer you back to the first video in this series to fully understand the difference between these two, because that's a significant implication. If a party was injured by a breach of warranty and then they stopped performing their own obligations, that is, they thought they were out of the contract, then what in fact happens is they would be in breach, so they could get themselves into commercial trouble. That's why it's critical to understand the difference between a term that is of fundamental importance to the contract, a condition, or a term that is of lesser importance, a warranty. So that's the way we're going to handle termination, because that's really the way it's mostly going to play out in commercial settings. There are a couple of other situations where you might be able to terminate a contract. One of those technically is repudiation. So what we're talking about here is where someone hasn't technically breached the terms. If you've said, I'm not going to go through with it, because you haven't yet had to do anything, so you're not yet in breach, right? That's called repudiation. If you make it clear you're not going to go through with the contract, you would repudiate it. We're not going to examine that here, but you just should be aware of it. You actually do have a possibility of terminating if someone says they're not going to go through with the contract. We also remember from that first video, there are these in-between terms, quite technical. Just think major issue, probably you can terminate. A term of fundamental importance, super important, a very bad breach, you can terminate. A lesser term, you can't. Okay, so you still got to be wary about those lesser terms in the contract and understanding the difference between the two in your contracts if you're going to go down a termination route. And finally, there may actually be a clause in the contract that allows you out, or you may negotiate your way out. But that's not really about terminating a contract for breach per se. So just remember, breach of condition, you can terminate. Breach of warranty, you can't. So, as well as termination, there is a remedy that tries to address the injury, damages. Damages is just a monetary award, but it can be misinterpreted or it can be misunderstood if you don't understand the core philosophy going on. Okay, so the core philosophy is you should be given the amount of money that would put you back into the position you would have been in without the breach. It's not penalising the other party. It is to make the injured party whole, to restore them to the position that they would have been in without the breach. So let me give you an example. Just say you agree to wash my car for $20. And just say you don't wash my car on the agreed day at the agreed time. Okay, you're in breach of the contract. But how would the courts calculate the damages that would be due to me? What they'd look at is say, okay, what you have to do is try and limit your damages. So I would have to go and find another car washer. Maybe I go to the local car wash at the supermarket. I know that there's one underneath me, and I get it washed there. And I ask for the same service and just say it cost me $50 there. So what damages do I get? I don't get the $50. I get $50 minus the $20 I would have paid you. So really I would have got a car wash for $20. But I had to pay $50 to get the car wash because you breached your contract. So you have to give me $30, then I'm in the same position as if you had have fulfilled the contract. I got my car wash for $20 because you gave me the difference, the $30, when I had to pay $50. That's how damages work. Super important. It's the difference between the costs you incur to get what you bargained for and what you would have paid under the contract. How much money does it take to make you whole? Now, a second issue that arises is the injured party needs to ameliorate their losses. Now, what does that mean? Well, as far as damages are concerned, both parties have to do what they can to minimise them. Okay, so let's take the car wash example. You haven't washed my car for the agreed $20. Now I have to go and get my car washed. But I can't go on to Airtasker and offer $500 for someone to wash my car within the next 3 hours and then try and get $480 worth of damages off you. $500 for a car wash is too much. I'm not limiting it. I'd have to go to a reasonable commercial alternative. And some people would argue that even going to the shopping market was too expensive. What I really should have done was tried to get another student or a kid or someone like that to wash it, because going to a car park is a kind of different commercial outcome to getting you to wash my car. And I really should be only recompensed for equal. So a key thing is, if you've been injured in a contract, don't think that you're going to get all your money from the other party, etc., and you don't have to do anything. No. You have to do what you can to keep those damages as small as possible. Imagine you're running a restaurant and you have a supplier who is contracted to supply the meat for your restaurant, and they don't deliver the meat. Well, what are your damages calculated? Your damages are calculated based upon how much would it cost to get the same kind of meat to replace what the supplier didn't give you. You couldn't close your restaurant for 3 days saying, well, I don't have any meat, I can't serve anyone, and claim the damages for all of the lost business. You're not limiting your losses. To limit your losses, you have to go out and source some other meat, and within a reasonable period of time, that would be supplied, and then you could continue business. So they're the kinds of things that limiting your losses actually means when you're in business. Finally, in a similar way, damages can't be too remote. What does that mean? Just say you didn't wash my car and, I don't know, I'm making something up, there's bird poop on it, and that stays on it for 2 weeks and damages the paintwork, etc. That damage is probably going to be too remote from a simple car washing for me to get damages for the paintwork. I should have got it washed off, or I could have done something to wash it. It's too remote from the car washing for you to have to pay for it. So damages are not a lotto ticket win. They're minimal to put you back into the position you would have been on if the deal had have progressed as agreed in the terms and conditions. As well as money, there are 2 equitable remedies that we cover. Equity, you'll remember, steps in when the common law can't deliver justice. So when is money not enough? That's what equitable remedies are about. And we have 2 equitable remedies that step in when money's enough. The first is specific performance. Specific performance is where the courts will make an order for the other party to carry out the contract. An example might be you buy a block of land that is on the ocean with a specific view. Now, if the other party fails to transfer the land, you've got the contract, it's all in place, and they fail to transfer the title to you, so you don't really own it yet. The court can order specific performance, order them to transfer the title. Why? Because there's only one block of land with that view on that beach. Money can't make up for the uniqueness of that specific thing. So if there's a unique element to the contract, maybe it was an heirloom, your grandmother's watch. You could get a similar watch for a certain price, but you couldn't get your grandmother's watch. If it has this unique element to it, the courts can sometimes order specific performance. But again, a word to the wise, it's not as easy as it sounds, and it doesn't cover some things. So for instance, specific performance doesn't cover what they call personal services. So if I agree to clean your house and I don't do it, you can't get specific performance to make me do it. The courts have taken a view that that's very close to slavery, that you have even indentured yourself if you can be forced to do it. So there are exceptions. Think of things like unique heirlooms, a block of land with one view, specific unique things in a contract. The second time equity steps in is around an injunction. What's an injunction? An injunction is a court order for the other party not to do something. I don't know, maybe as part of the contract, they were renovating around your house and they're going to chop down a tree. There might be an injunction to stop them chopping down a tree or knocking down a building or giving information to someone, confidential or private information to someone, proprietary information. These things no amount of money can make up for. If someone published the Colonel Sanders 11 secret herbs and spices, you can't get that genie back in the bottle. So you can't really calculate damages. So the court might make an injunction stopping the person from publishing that particular recipe, for instance. So that's an example of an injunction. And these two, equitable remedies, specific performance, and an injunction, step in when money is not enough. Most of the time, the courts are going to use money, that is damages, as the remedy for a breach of contract. Woo! And so there we have it. We're through. We're out the other side. We learnt what a contract was. We talked about how you form an enforceable contract, what might stop it being enforceable, what's included in the contract, what is a term versus what is a representation, and then what happens if one of the parties doesn't fulfill their obligations under the contract. In the next module, we move on to another very important area of business obligations, that about taking care in business, negligence.